raise more questions. So the presentation today will probably raise more questions than it answers. That's kind of on purpose because I think what we've kind of identified here in the presentation that I'll give you is an area that I think is very fruitful from a research and engineering perspective, and also something that can make a massive difference really in a lot of different situations within the criminal legal system, certainly here in the US, but also around the world. And so I'm hoping that these questions that you raised that I'm not going to be able to answer will hopefully still interest you, and you want to keep thinking about and exploring it in the future, and touch base with me as you're interested. And so I really appreciate all the questions in advance. Feel free to interrupt with questions as you have them. So next slide. So the talk today is, as I mentioned, it's going to be primarily on this one paper called Adversarial Scrutiny of Evidentiary Statistical Software. And this is a paper where we identified a framework for auditing statistical software that are used as evidence within the criminal legal system here in the US, and also in many other countries around the world. So the focus is going to be these evidentiary statistical software tools, and in particular those that are used to generate evidence that can be used to convict individuals. So that's going to be our focus. So next slide. I want to start the presentation here with a story. Actually, before I start the presentation with a story, I wanted to highlight, if you go back one slide, I wanted to highlight my co-authors that you see here, but I especially wanted to highlight Angela Jin, who's on the top right corner. So she was the graduate student lead of this project, and just a really wonderful researcher here at Berkeley, or I'm not at Berkeley right now, but at Berkeley where I am, and also just a really wonderful researcher, gave a presentation on this at FACT, and is continuing to work on this. So I just wanted to actually take a second to highlight the junior person who made this paper happen. So, okay, next slide. Now we're going to talk about the story that I want to start with. So this picture that you see here is on the left-hand side is of an individual. His name is Mayor Herskovic. And in 2013, Mayor was convicted of a violent assault and sentenced to 4 years in prison. And Mayor lives in Williamsburg in New York City, and he's a Hasidic man living in that area. And it was a very unusual case, or an unfortunate case, in that even though he was convicted, as I mentioned to you, there wasn't really anything tying him to the crime. The individual who was assaulted did not identify Mayor in a lineup and say, "I recognize that man." This individual, there was, at the time of the trial, there was belief that he was assaulted by sort of a gang, but Mayor was not affiliated with that gang. No one believed that he was. Mayor did not have a prior conviction before. He did not have a prior criminal record before, right? So really an unusual, just almost as though if you picked up a random, man on Williamsburg, it was almost as random as that, right? But there was really one thing that was tying him to the crime. And there was, it was this piece of evidence. So next slide. It was after the crime had occurred, 6 days after the crime had occurred, almost a week after the crime had occurred, police found sneakers that belonged to the victim of this crime on a rooftop. And so it had been there for a week, right? So it's, degraded. It's been exposed to the elements, the sun and the air and everything. And from those sneakers, they found 97.9 picograms. So that's less than 100 picograms of DNA. And usually we set a threshold of about 100 to say, if your sample is less than that, then maybe that you don't really have enough to be able to do the analysis that you want to do, right? Because a picogram is 1/trillionth of a gram. It's really, really tiny amounts. These are tiny amounts we're talking about. So they were able to take that sample from these sneakers that had I think it was actually one pair that had just one shoe, I guess, that had been on the rooftop for a week, right? And they took the sample, they analyzed it, and they found that they believe there was 2 individuals DNA who was included in the sample, and one of them is, of course, the victim, right? He was wearing those shoes. But the other one, they had to figure out, and they did their analysis and concluded that it was 130 times more likely that the remainder belonged to Mayer, then not, right? And the way that they decided this was using a software that was built in-house, a probabilistic genotyping software that was developed in-house within their department. It's common that law enforcement agencies, police departments have their own inbuilt software of different kinds. This was one that they had, and it's not a software that had been properly validated or adequately validated, and we'll talk more about issues that we know probabilistic genotypers typing software have, but it probably suffered from the same issues that other PGS tools had suffered as well, right? And so they used this, they analyzed it, decided that it's 133 times more likely that Mayer's DNA was included in the sample than not, and that played a crucial role essentially in the conviction, right? And so again, recall that this was really the only thing that was tying this individual to this crime. That was it. He was not in the surveillance video. The individual did not spot him in the victim did not spot him in a spot in a lineup. Just really nothing really that was tying him. And Mayer's lawyer argued several things. Argued that even though this kind of software can work in some cases, right? We know that probabilistic genotyping software can work well if you have a sample that has just a single individual's DNA, and you have large quantities of it, right? So when you get your blood drawn, right, they have like this cup of just your blood, right? If you use it on that, it should work, right? And it often works because it's just one person, you have large quantities of it. But if it's a tiny sample and it includes multiple individuals and it's been degraded and all these things that can go wrong, then we're not so sure, right? And in particular, what the lawyer argued was that in cases where you're using this DNA's analysis method when individuals' biological relatives could be included, right? So let's say that there's a sample, it includes my biological sister's DNA in it, right? But not mine. But you analyze it, me and my full biological sister share a lot of our DNA, and so it could actually lead to significant confusion in that situation and potential wrong conclusions as well, that my DNA was included as opposed to my sister who shares her DNA with me, right? And so the lawyer argued that in these cases we know that it struggles, and in this case it's very important because the Hasidic Jew community in Williamsburg, which I mentioned to you, Mayer belongs in, is one of the more genetically insulated communities that we're, that you might encounter, right? Because it's a community. It's kind of more, it's more kind of like clustered, right, and sort of genetically insulated. And so there's a lot of individuals who likely share many of the same ancestors, right? And so they also share much of the same DNA. And so in these types of situations, you expect these probabilistic genotyping software to really not work quite as well as you'd like them to, and potentially lead to wrong conclusions. So next slide. And sort of arguing this, the defense counsel, Donna Aldea is her name. She said a quote that I really like. She said, this case, this criminal case that I'm mentioning, is a poster child for how DNA evidence can literally be fabricated out of thin air, and how statistics can be manipulated to create a false impression of scientific evidence of guilt, right? And I really completely agree with this analysis, because as I mentioned, this DNA evidence was really the only thing that was playing such a significant role in the conviction, right? Without this piece of evidence, it's very likely that he would not have been convicted, right? And sentenced to 4 years in prison. And so this was something worth highlighting. And another thing worth highlighting was also that, a lot of the coverage around this highlighted that the state, had waited until the day before the trial, the eve of the trial, to provide underlying notes and methodologies that were used in this analysis, and this DNA analysis that I mentioned, which deprived Herskovich of effective counsel because they just didn't have enough opportunity to adequately analyze even the sort of the write-up of these results, right? Let alone the actual software itself and being able to properly validate it. And so, so you can kind of think of this as like the equivalent of, if the only piece of evidence that they had was that someone said, I saw this person at the scene of the crime around the time that the crime occurred, right? If you had such a witness, and they took the stand to make this statement. They do this under oath, right? And then they also you also have in the U.S. you have the right to cross-examine them. You have the right to cross-examine your confront, your witness, right, and say and just be able to even look at them, but also to cross-examine and say, how's your eyesight? When was the last time you got your, glasses, prescription refilled? I don't know. I don't wear glasses. I don't know what happens with glasses, but, things that are meant to sort of scrutinize, right? This piece of evidence that's being brought to court and being used against you, you have that right. And yet with the software, we don't necessarily seem to be seeing that in the same way. We don't necessarily seem to be seeing the same ability or practice, I should say, of being able to question the software and say, has this thing been tested in situations where the individual might be belonging to a community that's more genetically insulated, and as a result, it could lead to sort of wrongful conclusions, right? So we don't really see that practice as much as we really should. So next slide. And we really see these probabilistic genotyping software falling apart many different places. So there's cases where two probabilistic genotyping software, PGS tools, very popular ones, had been used on the same sample in the same case, and they led to divergent conclusions, right? So had it been just one of them that had been used, then maybe that would have led to conviction, and maybe the other one would have undermined that case a lot more, right? And so these are situations that could have led to divergent conclusions, even in kind of conviction potentially, if you're finding that you're identifying sort of different strengths of evidence of the individual being connected to a crime based off of which software you happen to be using. There's been cases where there was coding errors that affected dozens of cases in Queensland. There's been situations where the software would lead to kind of nonsensical output, right, of just like probability of greater than 1. That doesn't make any sense, right? And things like that. And these are just the ones that we happen to know. Who knows what else is happening, right? And so even with just what we can find sort of more publicly, and what the defense counsel have been able to sort of extract, that we've been able to see that there can be a lot of issues. So next slide. And there's a lot of reasons why this might happen, why these validity concerns might emerge. The number of contributors is a pretty big one, right? If you have a sample that has 2 people, one person, that's much easier. 2 people, still okay, right? But if I tell you it's 5 people, that's a lot of people. It leads to actually a lot of confusion, right? Because of the way that these tools work and how they try to identify different alleles that belong to different individuals. So that can kind of make it much harder. Or it could be unknown. I could say, here's a sample from a doorknob, and it might be a doorknob that's in a house that has, or like in a building that has, any number of people touching it, right? And so then you don't even know. You don't know how many people have touched it. You also don't know, the relative proportion of material from different individuals. It could be the case that one person, like really passes through that door a bunch and so touches that doorknob a bunch, right? And so they contribute more of the more sample than someone else who's only passed through once and only touched it once, right? You don't know. And so this relative proportion can play a very big role. The amount of DNA collected is a very big one, right? So there's this threshold that I mentioned to you that sometimes people try to keep in mind of 100 picograms, but ideally you would have a much larger sample, right? And just a lot of other issues, like I mentioned to you, sort of the amount of kind of material included from DNA material included from biological relatives can also influence outcomes in terms of deciding whether someone's DNA was included in a sample versus not, and so on and so forth. And so there's a lot of really pretty serious issues that could lead to validity concerns. If you're interested in learning more about this, there's a NIST study. So NIST is one of the government agencies here that does a lot of things, but one of them is that they kind of put out these reports that can be very interesting. So this is one of the ones that I think is really interesting if you're interested in thinking about DNA mixture and broader concerns around PGS tool validity. So I highly recommend that you take a look at it. But you could also look at this quote. So if you go to the next slide, there's this quote that I like from Mayer himself, where he said, a mixture take milk, orange juice, and water, and you mix it. What is it? Is it still milk? Is it still orange juice? I don't know. DNA is the magic word. If you throw it in a trial, they eat it up. For me, it's not magic at all, right? And if you go to the next slide, you can contrast how he's describing this with sort of how things are talked about in courts. So there's this case from 2016, and I only really want to highlight one quote from it, although the whole case could be of interest to people too. But this is a case where a lot of expert witnesses spoke, like a probabilistic PGS tool. One of the popular ones called StarMix was used in this case. There was a lot of kind of discussion that happened around this. And in the case file itself, it says that StarMix, this PGS tool that I mentioned, also employs Bayes' theorem, which is a general scientific principle of the likelihood ratio. Bayes' theorem was developed in the early 1700s and has been used for centuries in various scientific disciplines without controversy, right? This is, I mean, when I first saw this, I just was so amused, right? To be able to say this with a straight face is really impressive. And it really kind of shows, right, where if you're sort of in this area, in this general area, then you kind of see what's happening here, right? It's a very if you're sort of like a general in the general population, a random person off the street, you don't know what Bayes' theorem is. You hear the 1700s, you're like, that was a really long time ago. You're telling me that it's used in a lot of scientific disciplines, and you're telling me it's being used without controversy. So great, we're done here, right? So you kind of walk away with a false sense of confidence, right, and in what's going on. But the reality is far more complicated, right? And so what we really see is that, you know, if you go to these court files, which, you know, we did, you find that the way that these types of tools are discussed and the way that the underlying methodologies are discussed can be pretty misleading to a general audience, right? And you know, there's a lot of incentive issues here that kick in. You know, if you have an expert witness who has material interest in these tools being used, right? Let's say that you work for the company that created StarMix and you're an expert witness. You know, you have a conflict of interest. You want a particular kind of outcome. You want these tools to be used by these courts and by others, right? You want them to be used because then, you know, your company is able to kind of continue to sell these products. That's just a conflict of interest. Anyone would be susceptible to that, right? And so it's very dangerous to rely heavily and at times exclusively on people who do actually have a particular kind of interest and a particular kind of outcome in the use of these tools. But you don't necessarily see sort of the other side, right? The defense side being able to scrutinize these tools and say, you know, actually, we know that they don't work in these situations. And so there's a sort of imbalance that you see here. Next slide. And despite this, you know, significant imbalance that I mentioned, unfortunately, these tools are used in a lot of cases. So it's known that PGS tools have been used at least 200,000 times in cases around the world, including, you know, several thousand cases here in the US, I believe. And you know, for a lot of trials, they have actually made the difference between a particular kind of conviction outcome versus not, right? And so they really play a very serious and significant role. Next slide. And it's not just PGS tools that are being used as evidence. There's a lot of other software that are also used to generate evidence, to generate these kinds of conclusions that could tip the scale in terms of convictions, as I mentioned to you. The ones that I show you here are just a sample. There's a lot of different ones, from breath testing devices to toolmark analysis to environmental audio detection, and really many others, right? So we believe that there might be hundreds, who knows, maybe even thousands of these tools out there. As I mentioned to you, different labs can create their own in-house software. There's about I believe over 200 different labs here in the US, right? And so if each of them create, you know, one of their own software for a particular use, right, now you're already at 200. So we really don't know how many of these software there are out there, even just here in the US, and certainly not around the world. And we don't know, you know, how many of them are sort of more of the standard tools that are being used, which also have their own issues, or ones that are in-house. So it's a really it's a really, I would say, scary situation, right? We really need to know who's generating, how are we generating evidence that could lead to people's incarceration. And one that I just want to highlight before kind of moving on to the framework that I want to mention to you is on the next slide. It's from one of these tools, ShotSpotter. So ShotSpotter is an environmental audio detection. So next slide. it's an environmental audio detection. So what it does is it listens to sort of sound and in a neighborhood, right, where it's put. And if it hears something that it believes could be a gunshot, sounds like a gunshot, then it alerts the local police departments, and the police then arrive at the scene and they look around and see if there's evidence of gunshot. And if there's not, presumably you would kind of walk away and just go back. And if there is, then you would attend to whatever the issue is that's going on. But of course, the reality is a lot more complicated, right? Often what happens is, this software, alerts the police when it believes that it heard a gunshot. Maybe there's not, maybe it was just like a car, I don't know, backfiring. I don't know if cars still backfire. I know they used to a while back, but it could be anything, right? You live in loud neighborhoods, stuff happens, right? So yeah, it could get confused and think that that was a gunshot. The police show up, they see no signs of gunshots, right? Or guns being fired, but now they're on the scene. They might find something else, right? They might use that as an opportunity to just kind of look around, right? And in communities that are heavily policed and communities that are that already have a lot of interaction with the criminal legal system, then we know that the story does not end there, right? Often, and so it's a tool that where these false positives could really have these can create these vicious cycles for communities. And ShotSpotter is used, really, really heavily in some areas. So in Chicago, where I am right now, it's installed in 20 to 20. There's like 20 to 25 microphones per square mile, right? In 1 square mile, you have about 20 to 25 of them. And in Chicago, where I'm based, we know that it creates ShotSpotter creates a lot of false alarms and sends police on numerous trips. And in Chicago, that could be, it's estimated that it's like 60 times a day, right? Where it creates a sort of false positive and then sends the police to those neighborhoods 60 times a day. That's a lot of times. So next slide. So, hopefully now you're kind of also seeing the sort of the gravity of using these evidentiary statistical software without their proper validation in courts. Because they're kind of being more and more used in these courts, it becomes pressingly important that we are able to properly audit and validate them before we're able to use them. And next slide. And in the past several years, especially, there's been a lot of discussion of the use of algorithms within the criminal legal system. So here in the US, if we look at the different types of software that have been now kind of more central to conversations within the broader research community, we see things like risk assessment tools and facial recognition technology and other things that you may have heard about. And a lot of times these tools, at least at present, they're used at the pre-trial stage and investigation, right? So they're not used to generate evidence, they're not used as evidence. And it's not to say that they will not be in the future. It's possible that facial recognition technology is actually headed in that direction. But right now that's not the primary use, right? And the use of not properly validated tools across the whole spectrum, across the whole criminal legal system here in the US is not good, right? You need to be able to properly validate things and make sure that they work before you're using that to make these incredibly consequential decisions that can permanently alter the course of people's lives. But in the instance, especially where we're using it to generate evidence, there's a lot of other things that kick in, right? Like I mentioned to you, if someone was a witness against someone, right? There's a lot of things that happen, right? They're the individual, like you have the right to confront this witness, you have the right to cross-examine them, and so on and so forth. And so that same kind of process should really be applying to the software as well. They are, in some sense, serving as some sort of like witness, right? And saying that, I believe that this person's DNA is included in this, or I believe that there was a gunshot. It's almost, that's not like a terrible analogy. And yet we don't see the same practice of being able to kind of scrutinize them in the way that we would if it was an individual. So next slide. So as I mentioned to you, these software are used, for a lot of different stages for plea negotiation, admissibility hearing, and trial. Admissibility hearing is a sort of a practice here. It might also be at other places, but here in the US, it's, when you have a case, you have the prosecution might bring forth, any number of things as possible evidence, right, that they would like to kind of enter. And the judge has the ability to hold these admissibility, or I guess like the defense counsel can request them. You can hold these admissibility hearings, and they're meant to sort of filter relevant evidence from not, right? So it's not to say that the evidence is perfect or that it implicates innocence or guilt, but rather is it relevant or is it not necessarily relevant? And if this piece of evidence is just like junk science, right, or it's just not at all relevant to what's going on in the case, then the judge has the ability to just dismiss that, right? And so a lot of these tools are now kind of infiltrating the criminal legal system because they are able to go through these admissibility hearings and kind of go past that. And if you go to the next slide, it's not just with these evidentiary statistical software. There's a lot of other types of evidence that are really junk science. I mean, there's like a John Oliver episode on this, I think, about these types of forensic evidence that just don't make sense. People have used like bite mark analysis is one, right, where they find bite marks from the scenes of crime, and then they try to match that to an individual, but it's been kind of debunked essentially as something that we really should not be using, and yet it has been used, it is sometimes used, right? And so it leads to a lot of wrongful convictions. And the Innocence Project, which is this really incredible project that you might have heard about, has identified that the misapplication of forensic science more generally has contributed to at least half of wrongful convictions in the cases that they've been analyzing. Right, and so, and increasingly now, this faulty forensic science is really coming from faulty forensic, from faulty digital forensic science, right? From these evidentiary statistical software, as I mentioned to you as well. So next slide. And so, given that we are in this case where we're increasingly relying on potentially invalid output from evidentiary statistical software, we might ask, why aren't current existing mechanisms actually able to do a good job? So if you go to the next slide, I highlight a couple of things that are existing mechanisms that ought to be catching some of these issues. You can roughly cluster them into sort of source code review and validation studies. I'll focus on validation studies because it's relevant to the framework that I want to highlight. So there's these two sort of standards that hold in the US, the Daubert and Frye standard. So the Frye standard is from 1963, and the Daubert standard is from 1993, so 30 years later. And the Frye standard was kind of more vague, right? It said that the tool, methodology, theory that you're using has to be sufficiently established to have gained general acceptance in the particular case that you are in the particular field that that this kind of tool or methodology or theory belongs, right? And so if we're using evidentiary statistical software, the idea is that these methodologies that you're using and building it and the software, application process itself should have gained general acceptance in the particular field. So in the PGS tool instance, this could be sort of more broadly statistics, but then also population genetics and other relevant fields that might factor in, right? And then the Daubert standard is a little bit more specific, right? It says that the methodology or theory or technique can be or has been tested, that it's been subject to peer review, and there's an understanding or a belief or at least a desire that this peer review be independent, and that any known or potential error rates are kind of disclosed, that there's standards that exist and are being maintained, and that it's attracted widespread acceptance within the relevant scientific community, right? So it's a little bit more specific. A lot of times we can translate it to kind of specific cases that we have in mind, right? But really all of this says that you can't just, randomly make up some software that has not been validated and then just use that to generate evidence and then use that to incarcerate individuals, right? Really, there ought to be a lot of things that we check for to make sure that it's not junk science that we're using to make these consequential decisions. So if you go to the next slide, there's a lot of limitations that we've seen here already. There's a lot of times we see that there's not really a lot of independent validation. A lot of these software, or many of these software, are not keen to give access to outsiders to validate them. Sometimes they do their own internal validations, but they're I've read the one kind of report from ShotSpotter that I think is kind of meant to be a sort of internal validation, but there's just a lot of different issues with it. And to our knowledge, there's not been a peer-reviewed independent outside independent validation of ShotSpotter that we know of, period, right? And yet it's been used, but in a lot of different cases. And then even when people do these validations, you might still find that there's involvement from those who have financial and professional interests, as I mentioned, right? So if you look at PGS validation studies on Google Scholar or something, you might find that the names of two individuals in particular, Mark Perlin and John Buckleton, might appear a lot in the co-author list. These are individuals who are who work at companies, two different companies that produce two of the more popular probabilistic genotyping software, StarMix and TrueAllele, right? And so, so there's just a lot of issues with these studies. They are not conducted, and when they are conducted, they're not really fully independent, right? And so there's it's very difficult to kind of take that to heart. And the other thing that's maybe a little bit more subtle but no less important is that a lot of times when we do these validation studies, we kind of try to do a sweep, like a broad sweep, and say, this tool works like 99% of the time, and then maybe you focus on like some specific populations. Maybe you divide up the populations by gender or by race, right, which is important. And then you try to see, how well it does across these subpopulations. And maybe you stop there, right? And let's say that I have a PGS tool that works 99.9% of the time. That's really amazing, right? That's a really, really high, rate. But if I was to tell you that 0.1% of the time that it doesn't work, it disproportionately falls on individuals who are Native American, right? It's a small population here in the US, right? If I said that, then you would pause and you'd say, okay, that's not great, right? This is one subpopulation, it's a small subpopulation, but it's no less important, right? And this is a subpopulation on which this tool we know repeatedly fails. And so if your client, if you're a defense counsel, your client is belongs to this community, you would say, no, this tool does not work in this particular case. And so I don't really care if it's 99.9% accurate in any other case, but in this one particular case, which is relevant to my client, it does not work, right? And so we should not be using it in this case, right? And so this case specificity is incredibly important. So if you go to the next slide, so when you think about all of this in sum, right, you notice that it really undermines this adversarial system on which the US criminal legal system relies. So if you go to the next slide, so you may have seen this graphic here, right, with this scale, and the scale is really meant to sort of represent this process that we have in the US, the criminal legal system. So basically what you have is in the middle, you have the judge and jury. They're meant to be these sort of impartial group, right, that's meant to look at the evidence and kind of decide at the end whether they believe that someone is guilty beyond reasonable doubt or not, right? And on the one side, you have prosecution. So the prosecution is meant to prove guilt, right? So they're only meant to find evidence of guilt and present that and really kind of just really push for that, right? It is not their job to provide evidence of innocence, to argue that, to kind of undermine their own points. None of this is their job. What they're meant to do here is prove guilt. And then the defense side has the complementary role, which is to prove innocence, right? And so one of the ways that you can kind of go about this is in particular disproving or scrutinizing or poking holes in the prosecution's case when they present evidence of guilt. And so this kind of adversarial system that pits the prosecution and the defense against one another is meant to kind of create a system that ultimately could surface, what the actual truth is, right? That's the sort of the idea of the system, kind of in the abstract. In reality, it's a lot more complicated. In reality, it's a lot more imbalanced also, right? The defense side does not have necessarily the same resources and energy and time and everything to be able to kind of push back in the same way in many cases. And in this particular case that we're focused on, evidentiary statistical software, they don't even have access to the tools, right? Like I mentioned to you, the case that I mentioned earlier, they didn't even have the notes that they needed on the methodologies until the day before the trial. It's really, I mean, what are you supposed to do with that, right? And let alone actually gaining access to the software to be able to conduct their own independent validation study. So next slide. So we might ask, this is very important that the defense counsel is able to adversarially test and validate evidentiary statistical software. How can we go about this? So if we go to the next slide, so we've kind of looked at this adversarial scrutiny process in the law. So next slide. You might, if you're in sort of in the machine learning data science space, you might think that this kind of reminds you of adversarial processes that we have in machine learning, right? So if you're looking at sort of robust ML, this is a study where we look at how machine learning models can fail under certain adversarial conditions, right? So we could test them under sort of like distribution shift, adversarial input perturbation, changing subpopulation, so on and so forth, right? So you're really, you have your machine learning model in any area, right? You're kind of poking holes at it in the same way. So if we go to the next slide. So our main contribution in this work is really bridging these two notions of adversarialism in the law on the law side on the one hand, and the machine learning side on the other hand. And we introduce what we call robust adversarial testing, or RAT for short. That was it happened after we named it, and then now we're stuck with the name. But it's a framework for defense counsel for testing evidentiary statistical software. And next slide. If you look at this kind of framework at its core, what it asks is, it just asks, is this tool valid in cases similar to the defendants? So next slide. So there's two key things to notice here. There's the question of validity, and there's the question of similarity. So next slide. Validity, we are going to sort of check for using these quality check functions, right? So that could be, in the case that I've mentioned to you so far, it could be the rate of false inclusion of a defendant in a forensic sample. And this issue of similarity, we're going to capture using a sort of family of distributions that are meant to identify instances that are more similar to the defendants, right? And so let's talk through each of these in a little bit more detail. So for this family of distributions, what you could envision is that the defense counsel chooses characteristics that are similar to the defendant, and then it evaluates the software on each of these instances, on each of these distributions. And if it fails in even one case, then that's sufficient to say this tool does not work, right? So in the example that I've mentioned so far, you could envision that you have these two contributors, right? Actually, we don't even know if it's just two, it could have been three, but let's just say it was two. You have these two contributors, and there's the amount of sample that was collected, which I've mentioned to you is quite small, right? So it's in the 95 to 105 picogram range. So that's one case, right? Like maybe this tool does not work in cases where your sample is too small. The other thing you might consider is that this DNA comes from an individual belonging to the Hasidic Jew population in Williamsburg, right? So you could ask, has this tool been validated in instances where individuals belong to genetically insulated communities, right? So that's another case that could go wrong. And again, this could be independent of the amount of sample that you've been able to collect, right? It could be actually a massive quantity, and yet if this tool does not work in these types of situations, then that's enough. And then the third is the DNA being degraded if it's been exposed to outside conditions for a while, right? In this case, it's been 6 days. For 6 days, it's been exposed to just the elements. And so maybe even if you had large quantities, and even if you only had like a couple contributors, and that they don't necessarily belong to sort of subpopulations that are potentially genetically insulated, then maybe it's still not enough, right? Maybe the fact that it's been really degraded is enough to kind of create false conclusions, right? And so these are the three distributions you could have identified. There's maybe other things that you can identify, and crucially, also I want to mention that we're not even looking at the interaction of these things, right? Like maybe for kind of case 1, case 2, and case 3, for each of those in isolation, the tool does a good job. But then when you combine these two things together, then maybe it doesn't do such a good job, right? And so we're not even looking at that. But even then, you can still kind of look at these types of instances and identify them as these family of distributions that are meant to capture similarity with your with the defendant with the client, right? That the defense counsel is supporting. And then next slide.
Just a note about time. I was going to ask like maybe 5 more minutes, if that's okay.
Yeah, absolutely. Good. Almost wrapping up, yes. And then the last piece, the last lever that we care about here is this quality check function, right? So the defense chooses a check function that's appropriate for the particular evidentiary statistical software, which I mentioned to you, like false inclusion could be one of these, right? And so the idea is that you now are sort of choosing an evaluation metric that's appropriate for the particular case at hand, and this check function would take as input the software, and a distribution. The function would output whether the software passes or fails the quality check, right? And so, for instance, the defense might choose that we might choose the inclusion error rate as the sort of the metric that you're focused on, this false positive rate, and you use that on a data set and check whether the error rate exceeds 10%, right? So this is some threshold that you set, and if it does, then it fails, right? Because it's that the error rate is quite high, and if it doesn't, then it passes. And so that's kind of the idea. It's sort of piecing together all these different elements that I've mentioned to you to give kind of empowerment and ability for the defense counsel to be able to scrutinize these tools. So next slide. So we're just gonna gather all of this together into this definition of robust adversarial testing, but you've heard all the different pieces, so we don't have to spend so much time on it. Next slide. So now that we have this sort of definition, as I mentioned to you, you can operationalize it by compiling a large database of inputs, right, that you'll need. You can choose your family of distributions, and then you choose your quality check function, and you're kind of ready to go, right, to test whether this tool passes or fails. So if you go to the next slide, there's a lot of really interesting uses for this. As I mentioned to you, I think it creates a lot of really good synergy between the adversarial machine learning community on the one hand, and the sort of the law on the other hand. It provides the framework for audits. Audits are playing an increasingly important role in conversations within the sort of broader space of understanding algorithms and their impact on society. And these audits are, they're conducted in all different types of domains. And despite sort of like the increasing prominence that they're taking, we're still sort of struggling to identify, proper frameworks, right, for doing audits and sort of streamlining that process. And so what we've presented here is kind of a stab at that for this particular use in the legal system, in the criminal legal system in the US. And it also, what we've contributed here expands the scope of accountability, algorithmic accountability, to include instances of evidentiary software as well. So we go to the next slide. There's a lot of reasons why we think this is actually a feasible framework to implement. I won't get into it, but if you're interested in the details, you can look at the paper. But at the same time, next slide, we're also aware of the various structural and institutional challenges that could play a significant role in limiting implementing this framework. So if we go to the next slide, we highlight sort of a few of these in the paper in more detail. You can take a look. It's concerns around like trade secret arguments, under-resourced and overburdened public defenders, the significant amount of time and energy required to test these software. But we also think that the machine learning data science communities can really make a big difference here, right? That we can perform these audits, we can build off-the-shelf tools that can make it easier for other people to perform these audits. We can support organizations by like PD Query, which is an organization in the Bay Area that by creating, affidavits and cross-examining questions to make it easier for defense counsel to question and scrutinize the evidence that's put in front of them. And so there's a lot of really different ways that we can engage. So if we go to the next slide. As I mentioned to you, there's a lot of ongoing work here. So this summer we have 4 fellows joining us from Brazil who are performing some testing audit experiments on the ability of probabilistic genotyping software. And we're specifically focused on inclusion of first and second order relatives, biological relatives. But there's a lot of other things that we're doing. We're holding a workshop at NeurIPS specifically focused on this adversarial framework in bridging the law and machine learning communities. And so if you're interested in this, we're going to be sharing a lot of open questions and a lot of resources there, and we're going to have collaborative exercises and so on. And so we're going to announce that the website will be up sometime in the next few weeks, but just giving you a sneak preview into this event. And we hope that you're able to join if you're attending NeurIPS in late November, early December. And final slide, I will just end here by saying thank you. And as I mentioned, this is ongoing work that's being done by many members of the BMO research community, which is the research group that I run at Berkeley. And there's just a lot of things that we are working on, a lot of things that we want to work on. And so if you're interested in this, I hope that you will follow along and also join us in kind of tackling some of these questions and concerns. And with that, I'll stop and thank you all so much for your time. see. Okay, so I can jump in and see and answer some of the questions that I see on the chat. Is that okay?
Yeah, okay. Thank you very much. I just wanted to say that for this is very interesting, and I think also really intriguing, and also very, like, I don't want to use the word scary, but then also I think it's sobering.
Scary.
In
It is
thinking
sobering.
about these things.
Sobering is a
Yes. But yeah, you can go ahead and pick a question and
yes.
go ahead. If there are questions also, you can raise a hand and then I'll acknowledge you before you can then unmute. So yeah.
Okay, very good. So the first question says, how does it differentiate between gunshot and a firework? It does not. I don't think it does. I mean, that's a good question. There you go. There's your validation study right there, right? You can test for gunshot and fireworks and see when it gets, when there's like a false positive or a false negative, I guess. I think that there's it probably struggles quite a bit, actually, and we don't know. We have not been able to do an independent validation study, so we don't actually know. So very, very good question. We don't know, and that's a concern. And the second question says, in terms of these microphones, are they only collecting gunshots or other interesting sounds? I mean, with race and global population surveillance, has there been cases reported so far? Good question. So I don't know the details of the study, so you'll have to look it up. But I think the ACLU was interested in this, in particular, to try to understand whether it also just picks up conversations, right? Because that, would increase the level of surveillance that's going on here. And I think they did not find evidence that it does pick up conversations, which is not shocking to me, because conversations are not so loud and these things tend to be put very, very high up. It's not to say that that might not change in the future, right? There's nothing that necessarily stops that, and it's not even clear that we would know if that was happening, right? So this is it's an important question to keep an eye out for. I think right now we don't have evidence that it does pick up, say, at least conversations, but there might be other sounds that are also sensitive that it picks up, and so someone would have to actually gain access to this tool and actually be able to do this validation study. And then someone asks, I guess same individual asks, if I may, where do we draw the line between what's junk and what's not, especially in our times, technological escalation? Isn't this a dilemma faced by the West? If they don't do it, China will, and it widens the gap even more. Yeah. So if I don't do it, this other person will, is an argument that we hear a lot. I think it's I don't know if, like, in debate culture, there's a way of like calling out arguments that are, that are meant to be tricks, right? Like, if I don't do it, someone will, is just, I think it's not a valid reason for doing something, right? Because maybe no one will, maybe someone will, but you didn't do it. And so your hands are clean from that, right? Maybe that itself is a good thing, right? So I think that's not good. In terms of drawing the line between what's junk and what's not, I think in the evidentiary setting, this is a space where I actually would draw a very firm line and say that we should just assume everything is junk unless we have proven otherwise, right? Because these are things that make such consequential decisions about people's lives. So if we don't have people who do not have any vested interest in a particular use, but who have the expertise to validate this tool, if we don't have such individuals being able to say very confidently this thing works in these settings, then I don't think it really crosses the bar. So I would say that rather than doing what is kind of happening right now, which is to say that it should be used in all cases unless it's been proven to not work, right? That there's this, we kind of like almost whitelist everything and then try to find exceptions. I would go the other direction. I would say it should not be used unless you know that it works in the particular types of situation that you want to use it, right? I would go the other direction. And so, yeah, I think this is an interesting question. I think challenging question, but I think in the case of evidence, I would draw a very firm line. Yeah.
I would like to maybe Michael, you can unmute and ask your question, and then we'll go back to the last question that's in the chat.
Okay, thank you so much. Thank you so much for an incredible presentation. Very thought-provoking. I'm very sensitive to the idea that policymakers in the states don't necessarily have the skill set, competency, or thought process to adjust legislation based on the science and the hard facts. So on the one hand, you point out an incredibly important fact and a need for fact checking and a need for truth. And on the other hand, legislative officers in the states don't necessarily have that skill set, capacity, understanding, even when it comes to rudimentary differentiations between what is fallacies and what is real. How do you intend on articulating your work to that level?
For some reason, I don't know, we can't hear you.
Oh, sorry. That was, yeah, I had muted myself. I apologize. Michael, were you asking about how to articulate the work to the legal community and people sort of deciding on legislation? Was that the question?
Yeah.
Okay,
So from an academic perspective, how do you translate that work to make an impact at a policy level?
Yeah, very good question. Yeah, so we, this work actually happened in a very bottom-up way. So I spent a couple of years working with Rebecca Wexler, who is one of the co-authors on this paper. She's a professor of law at UC Berkeley. And I just talked to her for a while. She introduced me to a lot of people, including several public defenders that in Queens and Brooklyn that who really actually shaped a lot of what we ended up doing. Talked to folks at Legal Aid, talked to folks in public defenders, public defense offices, people supporting those communities, right? And then a lot of organizations that civic organizations that are involved in the space. And so we actually kind of went in the other direction. So we really just engaged with that community and also impacted individuals, and then kind of worked our way back to what is a research question that we could answer here that could be useful. It was a process that was, unfamiliar to me, but it was, I think, necessary in this setting. And so because of that, it's actually been easier. I've had a much easier time than in the past to communicate that these findings and these insights back to these settings. And so, of course, changing legislation, right, takes a lot of effort and time. And so I haven't, not enough time has passed for us to know exactly how much of a difference this might end up making, or it might end up being attracting the attention of various policy folks, right? But there's, I can tell you that there's just a really huge appetite for talking to people with the kinds of expertise that we have here, but also, but are also interested in kind of supporting, right? And so, yeah, I think our academic institutions don't necessarily support doing this kind of work that bridges research and practice, at least not, going all the way down, right? Maybe if you do the first thing, it's nice, but like, if you're really not just like getting into the weeds of it, it's not necessarily all that incentivized and not necessarily always supported, but I do think it's worthwhile. So yeah, I mean, it is a lot of work translating between different communities and learning the language of different communities enough that you can speak to them, but it's possible. And so far, in our case, we've been able to work directly with a lot of different stakeholders, and we're continuing to push on the legislation side too. And so hopefully we'll have, more concrete things to report in about a year or so.
Okay, thank you. I think the next question was, would you be testing your model on cases where the software has failed, or you're overhauling the frameworks used?
May I ask, what do you mean the framework used, like by the software itself, or?
Yeah, I guess that's from Tope. I don't know if he wants to unmute and ask the question. Tope? Yeah, I am mindful. Yeah, I think we'll have 4 more minutes. Yeah.
I can just answer what I think the person is asking. So yeah, so we'd be testing the model in cases where we think it could fail, right? So we discuss these different situations where we think that it probably doesn't do such a good job, and so the plan is to feed these software instances that would capture these challenges that I've mentioned, and then show that they're not doing such a good job in those situations. And so so that's kind of the first step in conducting these audit experiments, and then, or this is one of the steps, and hopefully the idea is that by highlighting many different situations where these tools are not working so well, that kind of brings us down in terms of like the faith and confidence that we have in how these tools perform, so that we can make sure that they're only being used in situations where they are known to be working. So that's the kind of way to kind of tackle the more broader patterns of use that we're seeing. So
yeah. Thanks for that. I think that's pretty much the questions. Like, I'll take it like going once. If there's any other question from there, I think the questions I would have really put in would be there. I guess maybe a final thought would be now, for many data science and machine learning researchers, like, what is that, those like 1 or 2 things that people should really be taking into account before going down this road with some of these applications?
Yeah. So the first thing I would say is that it's rare that these tools are purely computational, right? A lot, like I mentioned to you with the PGS stuff, you have to know population genetics. Someone on your team has to know population genetics, and in order to be able to make sure that you're actually conducting like a proper study with the environment, like with the shot spotter, for instance, you need a sound engineer, right, or someone who like thinks a lot about sound and how sound is captured and that kind of stuff. That's not training that I have, right? So I would not be able to do that. But if I was to work on that, I would find someone who has that expertise as well. And so the first thing I would say is don't jump around between different software and especially different types of software. Pick one that is of interest to you, and then find the expertise that are needed. You're not going to know everything. You need someone who's an expert in the things that you don't know, so that you're kind of able to proceed cautiously and sort of in a more responsible way. So that's the first thing I would say. And then the second thing I would say is that these things are very tricky, right? So you might feel like, okay, I should be able to gain access to the software, or I think that this line of direction is probably fruitful or not, right? And you can hit dead ends for any number of reasons. You can hit dead ends for technical reasons, which are familiar, of course, to us, right, as researchers and engineers, but you can also hit a dead end because someone just like doesn't want to give you the software. They're just like, I don't want to and I don't have to, right? You can hit a dead end because the conversation sort of turns sour for reasons that are maybe that feel kind of like a little bit dumb, right? You're just like, I don't know why we're talking about this, but here we are now. We're just stuck in this conversation, right? And so I think it's made me a lot more patient as a person, to be honest with you, to work in this area, to recognize that the upside is really huge, right? The use of these tools to me is, as you said, Vukosi, it's really sobering, right? It really is the difference between people being imprisoned versus not. I don't know how much more serious it can get than that, right? And so in that sense, I feel that resolve. But on the other hand, it's not easy to work in this area. And so I felt like it's made me a lot more patient as a researcher and as a person. And so I think that kind of recognition that things might not always work out in the way that you want them to, and sort of thinking strategically about how you want to proceed is incredibly important. I do think that there's just a lot that we can do here. So I really hope that people feel energized by it and are able to kind of keep pushing. There's a lot of different directions that we can push in from the data that we have available, from softwares that are open source or accessible, right? There's a lot of things that we can do. It's just we have more problems than we have hands. So I think it's a fruitful direction, but it is very unusual. It has been unusual for me. So yeah. Thanks for that thoughtful question. Yeah, thanks.
Thanks for that, Rediet. Hopefully enjoy the rest of your time in Chicago. Great city, especially in the summer. Thanks everybody for coming in. I think almost 90% of people stayed in for the whole period on this one. And it's a good way to start these seminar series for us it's winter going into the spring. And we'll look forward for those, I think, who are going to the Indaba. I guess we'll see you at the Indaba in the late August. Thank you. Enjoy the rest of your day, wherever you are, and we'll talk very soon.
Thank you very much.